All right, government students, today 4.4 virtual notes as we start to look at the rights of the accused when you start to interact with the government in a criminal proceeding. What type of rights do you have? All right, so learning what those criminal rights are, and also when the government can take away your life or your liberty. So we'll start with the Fifth Amendment. The Fifth Amendment is really, really important in a couple of different ways. Number one, that you have a right to not incriminate yourself, right? That you do not need to engage in what's called self-incrimination, meaning you do not need to be a witness against yourself in a trial. You do not have to testify. The prosecution cannot call you as a witness. Only you and your lawyer can make that decision. In addition to that, you do not have to admit your guilt. So anytime you are interacting with a government official, with a police officer, you do not have to answer questions. You do not have to answer any questions. Whether at a traffic stop, whether you're under arrest, you do not have to answer any questions. That is protected by the Fifth Amendment. So that's a really, really important protection that some people don't realize. In addition to that, you have the right of called habeas corpus. This is where law enforcement must bring a prisoner before a judge in order to prove why they shouldn't be released until the trial. So if there is a prisoner who is taken and has done some sort of heinous crime, taken somebody else's life, they have to then, the prosecution, right, the government has to go before a judge and say, hey, we believe this person should be held in confinement until trial because they are a danger to society, and they have to present their evidence for it. This is called habeas corpus, which literally means a right to the body. And it's a really important protection because otherwise, like, the government could lock you up. Sometimes trials don't happen for almost a year after the event and when charges are actually brought, right? That's a whole year that you would be losing of time from your family, of time away from your job, of so many different things in a situation where you could be innocent of that, right? The government has to have a good reason to be able to hold you before your trial. So that's an important thing. In addition to that, I've got a picture of O.J. Simpson over here because of this last one, the whole idea of double jeopardy. Right? This is not double jeopardy in the sense that you get to double your points while you're playing Jeopardy. No, this is you cannot be tried for the same crime more than once. O.J. Simpson's over here because he was found innocent in a very famous, very public trial after a long chase in the white Bronco and everything of his fiance's murder. And famously, the prosecution asked him to try on a glove that was like the key piece of evidence. He tried it on. The glove didn't fit. The glove didn't fit. And as a result of that, he was found innocent. Even though there was DNA evidence tying him to the scene, the jury found him innocent. He can never be charged for that particular crime ever again. That is one of the protections of the Fifth Amendment, right? In addition to that, you have the Sixth and Seventh Amendments. Okay, Sixth and Seventh work very much in conjunction. One is for criminal trials. One is for civil trials. Civil trials is where like you're going like citizen versus citizen, where criminal trials are government versus citizen. Okay? And in this, each person is entitled to a speedy and public trial. Okay? This has to be done so within a timely manner. The government cannot drag its feet. Now, how much is speedy? Well, it takes time to be able to work through all these cases, and a year sometimes is considered to still be a speedy trial. They also have a right to a jury of one's peers. That you are not going to be judged by people outside of your community, outside of your social standing and stuff like that. That is your peers who are going to be the ones who are making decisions. There's been a lot of expansion on some of these ideas historically. In addition to that, that location of the trial is going to be where the crime took place. So if a crime occurs, outside in say Kent County, the trial is going to be held in Kent County. In addition to that, you have the right to know what charges are being brought against you and the reasons for those charges. Okay, this is what we call an indictment. So you have access to all the prosecution's evidence. They have to notify you of any evidence that they find. In addition to that, they have to notify you of specifically what you are being charged with. You can't just find out miraculously during the trial. All of these things are protected by the Sixth and Seventh Amendment. In addition to that, you have the right to call witnesses in your favor. Right, the defense always has the right to call their own witnesses, and they have a right to confront the prosecution's witnesses. Right, if they call a witness against you, you or your lawyer have a right to cross-examine those individuals. In addition to that, you have a right to a lawyer. This was not always the case, and you'll find that out in class when we get to Gideon V. Wainwright. You did not always have a right to a lawyer. Okay? Now you have a lawyer. Anytime you are engaged in any type of criminal proceedings, you have the right to a lawyer. Okay? You have the right to waive that right, but you have, like, if you can't afford one, they will present you with one. They have to, and that is required by the Fifth and Seventh, the Sixth and Seventh Amendments. So, again, the Seventh is doing the same thing idea as the Sixth, just in civil cases. That leads us to the Eighth Amendment. The Eighth Amendment is dealing with limiting the judicial branch's power, specifically in dealing punishment. Right? One thing is this idea of bail. If you have committed a very serious crime, the government has evidence to hold against you. Okay? They can put what's called bail on you, where you have to pay a certain amount to the court in order to be able to be free until your trial. Okay? What the Eighth Amendment does is it prevents any excessive bails from being placed on a particular individual as being charged of a crime. So if you have a minor infraction and your bail is posted at $1 million, that would be a violation of the Eighth Amendment. In addition to that, it does not allow any cruel or unusual punishment. In addition to the no excessive fines in terms of financial limitations on punishment. But really, what the Eighth Amendment is trying to do is trying to make sure that the crime and the punishment match up, right? That the punishment actually fits the crime, and that it's trying to prevent any sentences that are extremely out of balance with the offenses that were actually committed. So if you steal something, right? If you commit grand theft auto, yeah, you stole something worth a lot of value. However, you're not going to be eligible for the death penalty. Right, you're not going to have a $1 million fine as a result of that. The actual punishment has to be in conjunction and in balance with the crime that was committed. What is cruel and unusual punishment? That's kind of where it starts to get a little bit more murky. The Constitution does not prohibit any forms of capital punishment. Okay, capital punishment is any type of thing involving the death penalty. And what the Supreme Court has ruled is that as long as due process is followed, as long as they follow that process established by law, the state or the federal government can carry out the death penalty for certain offenses. Some states have said no death penalty. Okay? Michigan is one of those states. A number of states have done this. Said death penalty is not an option. But not all states are that way, right? Texas has executed more individuals than any other state. Okay, the federal government still allows for the death penalty. But even the death penalty itself is going to be a long process. There's going to be a lot of opportunities for the individual convicted to appeal that sentence before that sentence is actually carried out. But really, this is one of the areas where courts have really struggled at defining the limits based on the Constitution of capital punishment. Some of the restrictions are listed here. So we've got, first of all, that punishment must be the result of what we call guided discretion. This is where they're attempting to try and standardize the rules that govern all the death penalty cases. So they're looking at, okay, it's only specific actual crimes that they can be, right? This is a couple of cases in the 70s kind of laid that out. In addition, the government cannot execute those individuals convicted of rape or child rape. Those offenses, while I would say are very heinous crimes, are definitely very, very serious crimes. The death penalty is not something that applies to those particular crimes. Again, this happened in the 70s with a case as well as one in 2008. Additionally, the government cannot execute individuals who are mentally ill. Right? Ford v. Wainwright, 86, right? Pennini v. Quarterman in 2007, both laid down further guidelines on those. And the government cannot execute any minors. If you are under the age of 18, the death penalty does not apply. So those are some of the limits on that. But really, what these amendments are doing, the 6th, the 5th, the 7th, the 8th, these four amendments, what they're trying to do is to ensure that the government can both keep us safe, but at the same time not limit our freedom too much. All right, it allows us to have freedom, but also have a safe society. And really, the way that they balance that is procedural due process. Right, that they ensure that there is a process that is followed already established by law before the offenses are committed that ensure that people are treated fairly when they have their targeted government power. Because the reality is the government has a lot more power than you do. They have a lot more resources at hand than you do. So if the government's going to target you, they have to have certain restrictions on them. Okay? And this is really where the idea that you are innocent until proven guilty comes from, is that you don't walk in and have to prove your innocence. No, the government has to prove your guilt. You don't have to prove your innocence. Okay? Big thing to take away, right? Government can take away life, liberty, and property. The government has a right to those things. But in order to safeguard those things, in order to protect those ideas, which are essential to America, right? All the way back to the Declaration of Independence, we need to have certain safeguards in place to prevent the abuse of power and the misapplication of that power. All right, to make sure that we have a truly more fair system. And that's where procedural due process does take place. Is it perfect? No. You're never going to find a perfect judicial system. There are always going to be guilty people who walk away, all right, and are free. There are always going to be some innocent people who are found guilty. But how do we continue to make it so there are more situations where justice is truly prevailing, where the guilty people of crimes are the ones who are found guilty in a court of law, where the innocent people are found innocent? That should be our goal as Americans, and being able to look at and really continue to keep looking at ways to improve our system, I think are very, very important. So that's that. We'll look into these rights a little bit more with a couple Supreme Court cases and such, and get a little bit further in depth with this idea of procedural due process and your criminal rights. All right, as well as looking into your Miranda rights and understanding those concepts. So we'll do those things in class. We'll see you there.